Firstly, I just want to say that the topic that we're going to talk about today, I'm going to give an overview to you on the summary procedure and summary suits under the CPC, that is the Civil Procedure Code, in civil courts. Now, when we talk about summary suits, I will give you a background about it, and then we'll go into it in a little more detail. There are going to be 5 talking points that I'm going to talk to you about. Firstly, what is a summary suit and what is a summons for judgment, etc. We'll talk about that briefly. Then we're going to talk about institution of a summary suit. Thereafter, we'll talk about the procedure, because there's a specific procedure prescribed in the CPC for summary suits. And then lastly, we'll talk about whether leave can be granted for defending a summary suit, and in which situations can leave be granted, whether it is conditional, unconditional, etc. And of course, in the end, I'll give you a few examples. That's the 5th talking point of when leave has actually been granted. And we'll briefly discuss when the advantages of this summary procedure and whether it has been a success or it is just another procedure on paper which does not help the disposal of cases. So let me talk a bit about summary suit. The procedure is governed under Order 37 of the Civil Procedure Code, which is a self-contained code. It contains everything there is to know about summary suits in our courts. It deals with a summary disposal or a fast-track disposal of a money claim. Now, what does summary mean? Summary procedure in law means a procedure without using the usual and customary procedures of going to trial, examining witnesses, etc. The Black's Law Dictionary, which is a legal dictionary, defines summary judgment as a quick decision of a court based on briefings and affidavits alone, where material facts are not disputed or where the court's opinion is used for judgment, which means that we don't go to trial at all in a summary suit unless leave to defend is given. A summary judgment is also known as an accelerated judgment. And the reason for that is clear in the name. It's supposed to have been issued much quicker than a usual judgment, which, as we know, due to the pendency of cases, unfortunately, our courts are so burdened that they take several years to come. A summary judgment often comes much sooner, and that's why it's known as an accelerated judgment. And that is, of course, the end result of a summary suit. So as I mentioned, it is a form of fast-track dispute resolution. It is governed by Order 37 of the CPC, arising out of a written contract. An enactment where some sort is to be recovered is fixed, and on a guarantee where the claim against the principal is in respect of a debt or liquidated demand only. So as we can see, these 3 situations. The first is, of course, a suit which is based on bills of exchange, hundies, and promissory notes. These are all negotiable instruments which fall under the Negotiable Instruments Act. And a suit based on the dishonor of one of these bills of exchange, hundies, or promissory notes would fall under the provisions of this act, because ultimately it is a money claim. A bill of exchange, of course, also includes within its fold a check, which is defined as a bill of exchange under the Negotiable Instruments Act. And therefore, a suit based on dishonor of checks also comes under Order 37 of the CPC. And in fact, a suit based on dishonor of checks is on a higher pedestal, and there's a greater level of scrutiny involved in scrutinizing whether leave to defend should be given, because of the fact that the Negotiable Instruments Act has several provisions which provide that there's a higher level of scrutiny to be provided. Now, suits which are also based on liquidated demands and debts are also falling within the provisions of this order. And therefore, these are all monetary claims, which are usually undisputed claims, and therefore they fall within this order. The essence of a summary suit is, therefore, it is a suit where the defendant is not given an opportunity to defend the suit as a matter of right. Unlike a usual normal suit where it's instituted by the presentment of a plaint, a summary suit is instituted also by presentment of a plaint, but the defendant does not have the right to file a written statement. He has to apply to the court for leave to file a written statement. And a summary suit usually, unless the leave is given, proceeds without a defense and without any evidence. And we'll come to the procedure shortly. Now, we will also talk about when a summary suit is instituted. There are two summons issued at two different points. The first is a summons to appear, and then the second is a summons for judgment. And each of these have to be acted upon within 10 days by the defendant, unless, of course, he can show that exceptional circumstances made him not appear within those 10 days. Now, let's talk about the advantages of a summary suit and the differences between a summary suit and an ordinary suit. As I mentioned, in a summary suit, there is no automatic right of the defendant to defend the suit. The defendant has to apply within a period of 10 days from the issuance of the summons for judgment to demonstrate that he has a valid defense. Only then will leave of the court be given for him to even defend the suit. And if leave is not sought for or is refused, then it is incumbent on the court to pass judgment on the summons for judgment without the procedure of going through an entire trial involving leading of evidence, cross-examination of witnesses, looking at additional documents, etc. As opposed to this, in a normal suit or in a suit which is instituted in the ordinary course, there is an automatic right to defend the suit, unless, of course, it is a suit based on admission or it's an ex parte suit, etc. But the suit usually proceeds to trial and is decreed only after evidence, etc., is led and there are final arguments on the same. As I mentioned, in a summary suit, there's no evidence unless, of course, leave to defend is given, and therefore it is a fast track procedure. The second is a summary suit a proceeding which is ex parte, or is it considered to be the same thing as a suit which is ex parte? And the answer to that lies in Order 37 itself. It is not the same thing as an ex parte suit, because in a summary suit, if leave to defend is not sought or is refused, then the judge or the court will proceed to issue the judgment regardless of the merits of the case, because it will proceed on the basis that it is a suit based on admission and the facts, the material facts in the plaint have been admitted. As opposed to this, in an ex parte suit, the court will examine whether the plaintiff has made out a case for grant of the relief, the horse or without the defendant even entering appearance. Now, is there any difference in limitation in instituting a summary suit as opposed to instituting an ordinary suit? And the answer to that question is no. There are judgments to the effect, and it's a well-settled proposition, that the time period for limitation is identical in a summary suit as opposed to a suit instituted in ordinary course. So therefore, for example, if I file a summary suit based on the dishonor of a bill of exchange, it will have the same period of limitation as an ordinary suit which is also filed on the dishonor of a bill of exchange. I always have the option of either filing a summary suit or filing a suit in the ordinary course, and therefore the limitation period is also the same. And what is the limitation period? Usually 3 years from the date that the cause of action arises, but of course Schedule 1 to the Limitation Act provides for different periods of limitation or for different periods when the cause of action arose. For example, if we see Article 35 of Schedule 1 of the Limitation Act, it provides that for a suit which is based on a bill of exchange or promissory note payable on demand and not accompanied by any writing restraining or postponing the right to sue, the period of limitation is 3 years from the date of the bill or the note. So it's 3 years, but the period of limitation commences from the date of the bill or the note. Now, The same thing under Article 34 is on a bill of exchange or promissory note payable at a fixed time after sight or after demand. The period of limitation is 3 years from the date from when the fixed time expires. So, of course, the starting point of limitation may be different, but the period of limitation is usually 3 years from the date of institution of the suit, from the date on which the cause of action arises. Now, save as provided under Order 37. Order 37, as I mentioned, is a self-contained code which deals with summary suits and summary procedure. Except as provided under Order 37, the procedure in relation to summary suits is identical to the procedure in relation to all other suits, which means that unless the Order 37 provides for a particular procedure in relation to summary suits, the procedure that is to be followed for summary suits is the same as an ordinary suit. While it is a self-contained code, if nothing is contained in that code, then one has to look at the general provisions under the CPC to find out the procedure that has to be followed. Now, we've spoken about what is a summary suit. Let's speak a little bit about institution of a summary suit. That's the second talking point, which is how is a summary suit really instituted? And what the CPC provides is that the summary suit is instituted by presenting a plaint which has to contain an averment, a specific averment that the suit is filed under Order 37. Firstly. Secondly, that no relief which does not fall within the ambit of Rule 2 has been claimed in the plaint, Rule 2 to the CPC. And thirdly, it shall say in its cause title that it is under Order 37 of the CPC. So these are the three requirements of a plaint which is filed to institute a summary suit. Of course, thereafter, a summons for appearance has to be issued under the appropriate form which is provided in the CPC. And then what happens when a defendant does not appear or does not enter his appearance? Then it is incumbent on the court or the judge that the judge proceeds on the basis that the averments and allegations contained in the plaint are deemed to have been admitted, and therefore the plaintiff is entitled to a decree for any sum that he has claimed. Now, it is different, as I mentioned, to a suit which proceeds ex parte for this reason. A suit that proceeds ex parte, a claim may or may not be a money claim. It may or may not be for a fixed debt or liquidated demand. And therefore, even if it proceeds ex parte, the court will have to apply its mind as to whether a plaintiff is entitled to those reliefs paid for the cause of the defense. That means the court has to decide whether the plaintiff is entitled to the reliefs, even if there is no defense. On the other hand, what the CPC provides is that a summary suit is only a money claim. And if the defendant who is properly served does not enter appearance, then or he enters appearance and leave is refused, then it is as if he does not enter appearance, then it is as if the allegations in the suit have been admitted. Of course, this only applies if the defendant is properly served as per the rules of the extant law, and this will not apply where the defendant establishes special circumstances of why he could not appear or why he could not answer or why he could not apply for leave to defend. What is the purpose of a summary suit, therefore? The purpose of a summary suit where there is no leave to defend or where the person does not enter an appearance is to expedite the hearing and to prevent unreasonable delay or obstruction by a defendant who actually has no defense. And that brings me to the third talking point, which is the procedure for summary suits. We've spoken about what is a summary suit. We've spoken about the institution of summary suits. But the procedure for a summary suit is really unique, and it is important that we study that if we are going to practice civil litigation. Because it is such a unique procedure that on every suit which is a money claim, you would usually file a summary suit unless, of course, there is a bona fide defense. Now, let's discuss what the procedure is. The procedure is really contained in Rule 3 of Order 37. And what it provides is that together with a summons for appearance, which has been issued on the defendant to respond to to enter appearance within 10 days, the plaintiff is also required to serve the plaint and annexures to the defendant. Now, this has to the notice, the summons has to state that the defendant has to, within 10 days of valid service, enter appearance in person or through a pleader. He also has to file his address in court of services of notice to him. All summons are deemed to have been duly served if they are left at the address given for such service. On a side note, what is valid service? Valid service also includes when service has been attempted to be effected, but the defendant or the person receiving the notice has refused service. So that is also considered valid service. Now, if a defendant passes the first step and enters appearance, that means within 10 days of the service of the summons for appearance, he enters appearance himself or through his advocate or pleader. Then thereafter, the plaintiff is required to issue the summons for judgment to him. So the summons for judgment is really the next step. Now let's talk briefly about what is a summons for judgment, because this is really the crux of what a summary suit is. A summons for judgment is effectively a notice calling upon the defendant to appear and show whether he has a valid defense, for which leave may be granted by the court to defend the suit. So a summons will say that you are to appear before the court and show whether you have a valid defense or not in order to obtain the leave of the court to defend the suit. After entering appearance through his advocate, and a plaintiff will issue a summons for judgment. It has to be in a particular format which is provided in the CPC, but that is the next step. And this is the crux of really what a summary suit is. Now, the summons for judgment has to be accompanied by an affidavit which shows the cause of action of the suit, the amount claimed, and stating that in the plaintiff's belief, there is no defense. The defendant may at any time within the 10 days apply to the court by an affidavit disclosing his such facts as deemed sufficient to entitle him for leave to defend. So after he is issued with the summons for judgment, he must within 10 days apply to the court by an affidavit disclosing the facts which would entitle him for leave to defend. Now, thereafter, the court may grant leave to defend unconditionally or upon such circumstances as may appear to the court to be just, provided that the leave to defend shall not be refused unless the court is satisfied that the facts disclosed do not indicate that the defendant has a substantial defense to raise, or that the defense intended to be put up by the defendant is frivolous or vexatious. And also provided further that where a part of the amount claimed is admitted, the leave to defend shall not be granted unless such admitted amount is deposited by the defendant in court. So therefore, when will the leave to, and we'll discuss this in much more detail in a few minutes, but the leave to defend is usually not to be refused unless the court is satisfied that the facts disclosed do not indicate that a defendant has a substantial defense to raise, or that the defense intended to be put up is frivolous or vexatious. Otherwise, the leave to defend must be given. That's what the CPC provides. Now, thereafter, at a hearing of summons for judgment, if a defendant has not applied for leave to defend, or if application has been refused, the plaintiff is entitled to the judgment forthwith. If the defendant is permitted to defend the whole or part of the claim, the judge may direct him to give security within such time as may be fixed by the court. The failure of Now, the court may also direct that the failure of the defendant to give the security would entitle the plaintiff to immediate judgment in the event the condition of security is not fulfilled. Lastly, the court may also excuse the delay of the defendant in entering appearance or in applying for leave to the court beyond the 10 days, because there's a 10-day period for entering appearance and a 10-day period also for applying to the court for leave to defend. And it is not the same as what is provided in the Limitation Act for sufficient cause. Now, sufficient cause is something completely a different concept. Here, the sufficient cause that is provided is the same as Section 5 of the Limitation Act, and it is not a different concept. Now, what is leave to defend? When can it be refused? When can it be allowed? When is it unconditional? When is it conditional? The Supreme Court has, in a number of cases, discussed this issue, and it has really crystallized when leave is to be granted, when it is to be refused, in a number of judgments, all of which have consistently held as follows. And I'll give you the general principles and then some nuances or some examples. So the first is, if a defendant satisfies the court that he has a good defense to the claim on merits, the defendant is entitled to unconditional leave to defend. So if he has a good case on merits, naturally, he will be entitled to defend. Now, at the time of considering whether to grant leave to the defendant, the court is not required to consider whether the facts shown by the defendant are true. The court has to consider whether, if those facts are true, if they are proved during trial, then it would afford the defendant a good defense or not. So that's the question which they have to consider. It will not come to a finding that the defense is true or not. It will come to a finding that the defense is a valid defense if the facts are proved to be correct. So that is the first situation. The second situation is if the defendant raises a triable issue on facts indicating that he has a fair or bona fide or reasonable defense. So it may not be a good case on merits, but it's a fair, bona fide or reasonable defense. Then also unconditional leave will be granted by the court. Now, if the defendant discloses, this is the third situation, if the defendant discloses such facts as may be deemed sufficient to entitle him to defend, merely sufficient, and if the affidavit discloses that at the trial he may be able to establish that defense to the plaintiff's claim, then the court may impose conditions at the time of hearing the summons for judgment and granting leave. Now, what are these conditions? The conditions being as to enable him, the conditions being as to the time of the trial or the mode of the trial. These are not conditions of security and not conditions of payment into court. So if the defendant discloses sufficient facts, then it is a case of conditional leave, except to the extent of security, etc. Now, lastly, or rather the fourth point is, in the event the defendant has no defense whatsoever, or the defense is extremely illusory, a sham, or moonshine. Now, these words have been used again and again in the context of leave to defend in summary suits. Illusory, sham, or practically moonshine. What does illusory mean? It does not exist. It's completely false. A sham means something which is false, fraudulent, etc. And moonshine, something which is completely unbelievable and something which does not provide a valid defense. In this case, the court will not give leave to defend. He will not even give conditional leave to defend. However, in the same scenario, if the defense is moonshine, sham, illusory, etc., then the court may show mercy on the defendant by enabling him to prove a defense, but at the same time protect the defendant by directing him, at the same time protect the plaintiff by directing the defendant to deposit a security in court or pay into court the amount of the claim or a part thereof. So these are the 5 situations of grant of leave, whether conditional or unconditional, and these have been laid down in a number of Supreme Court judgments, including Sunil Enterprises versus SBI, Uma Shankar's case, etc., etc. This is a well settled proposition that in these situations, leave has to be granted. In these situations, leave has to not be granted. And in these situations, only conditional leave has to be granted. As I mentioned, the question before the court or the judge is not whether the defense is true or not, because that will be decided at trial after the examination of witnesses, etc. The question before the court is only whether the defendant has raised a defense which, if he succeeds, has raised facts which, if he succeeds or in proving those facts, would be a good defense at the trial of the suit. So that really is the question which the court has to answer. Now, let me give you a few examples of what would be, when would the court grant leave to defend. One of the examples is a matter that I appeared in, where there was a money claim. It was essentially that my client had provided goods against a contract for him to be paid an X amount for those goods. Now, what the defendant said in his affidavit in reply to the summons for judgment was that, yes, we had to pay you this X amount, but since you owed us Y amount, which is a separate amount under a distinct contract, therefore we have set off your claim amount against our claim amount, and therefore we do not owe you any money. And this is a defense that they raised in the affidavit in reply to the summons for judgment. What we argued eventually, what I had argued was that there's a difference between a set-off and a counterclaim. A set-off arises from the same transaction, from the same contract. If there's an amount that I owe you and there's another amount that you owe me, those two amounts can be set off if it is based on the same transaction and the parties are acting in the same capacity, etc. Now, a counterclaim, of course, is based on a completely different claim. In essence, it is an entirely separate suit which is only couched as a counterclaim. A counterclaim is effectively a suit in and of itself. What we also said was we had not admitted the debt in the counterclaim, and therefore that would have to be determined by the defendant filing an independent suit or filing some other proceeding to determine whether we were liable to make payment towards that counterclaim. That was our rejoinder to their defense. And what the court held was that there was no defense whatsoever to the suit because, as I mentioned, their defense was based on a counterclaim, whereas only a defense of set-off can be a valid defense, where they have said that we've already paid you the entire amount. But here they were claiming a separate amount which had not been admitted by me. So therefore, what the court held was that it is not a proper or good defense on merits, and therefore the summary suit was decreed in the favor of my client. When will a summary suit be decreed and when will leave not be granted? As I mentioned earlier, when it is an admitted or acknowledged debt, a crystallized fixed amount, and there is no dispute as to the liability, then no leave will be granted to the defendant to enable him to enter any kind of defense, and the plaintiff will be entitled to a judgment, which is exactly what happened in my case. Then also an example that often arises when we see summary suits, a defense that often is raised by defendants is they raise technical defenses or on issues of jurisdiction, maintainability, etc. So some of the defenses we often see in a money claim are defenses such as the suit is barred by limitation, or that the suit is barred by the provisions of the Money Lending Act, which provides that where a money lender who is in the business of money lending does so without obtaining a license, then a suit to recover any amount or any loan which is based or which is advanced by the money lender is barred. So these kind of defenses we see quite often, because in a money lending transaction, The fact that the money has been lent is not disputed. The fact that the liability is to be paid is not disputed. But this is the only kind of defense that the defendant can raise, which is that I don't owe you money due to the operation of a bar which is available at law. So these are examples in which the court will determine whether it is barred by limitation, whether it is barred by the provisions of the Money Lending Act, whether it's barred by the Benami Act, etc. All right. And lastly, I just want to discuss briefly whether the summary procedure has been a successful one or not. It's been there since the inception. The summary jurisdiction, in a nutshell, is an extremely powerful tool in the hands of a creditor, especially when the liability or the debt is not disputed. Summary suits do not involve trial. They are faster, they are quicker, and there's none of the formalities of recording evidence, of interrogatories, of admitting documents, etc. So it is a much faster procedure, and so therefore, yes, it is very useful for a creditor. Having said that, if unconditional leave is granted, if there's a bona fide defense and unconditional leave is granted, you are effectively relegated to an ordinary suit, because if all the other procedures prescribed in ordinary suits will come into effect, the defendant will be entitled to file a written statement, give his defense, then there will be recording of evidence, etc., etc., and then the suit will be decreed only after the final arguments, which will happen, as we know, after several years or possibly even a decade or two. So, should you file a summary suit? Yes, if it is an admitted debt and if in correspondence or otherwise the defendant has not raised any dispute which would fall under the category of a bona fide dispute or a good defense on merits. Having said that, it doesn't help your case to file a summary suit if it is not based on a undefended or undisputed liability, because then, of course, you will be relegated to effectively having to go through the rigors of an ordinary suit. That is the summary of what I wanted to say. Summary, no pun intended, is the summary suits are very effective tool for creditors. All of us as civil lawyers, if we intend to practice in civil courts, must know this summary procedure and must advise clients of when to invoke it, because it's extremely useful and it saves time and money of the client. And ultimately, that is the ultimate object of litigation.
So going by the language of Order 37, now there doesn't seem to be any bar. There's no definition of what the defendant can be. So it can be either a person or a legal entity also.
Right.
Right?
That's right.
You agree with that? Huh?
Absolutely. Yeah. A defendant can be anyone. Same as in an ordinary suit.
Now, with the IBC also there, now there are like overlapping areas, right?
So I
understand. Summary suit and the IBC.
Your question is whether you should institute a summary suit or a proceeding under the IBC. Now,
the advantages and disadvantages.
Now there are judgments under the old Companies Act where we used to file a procedure for a proceeding for winding up of companies for inability to pay its debts. And there are judgments of the Supreme Court which say that a civil suit and a winding up petition operate in different spheres because they're for different reliefs. One is for recovery of the sums owed to you, which is a suit, a civil proceeding. And the other is for winding up or having an insolvency proceeding for a company because it is unable to pay its debts. So they operate in totally different spheres and therefore they do not overlap. And, people have tried to use the advantage of having filed a company petition first to take and later having filed a suit to say that we are entitled to the exemption under Section 14 of the Limitation Act, which says that I've been prosecuting a proceeding in a court with due diligence. And therefore, the period that I was prosecuting that proceeding, even if it's not maintainable, should be excluded from the period of limitation. And in that context, the courts have said that they are not overlapping proceedings because one is for winding up or insolvency proceedings and the other is for recovery of the debt amount. So to answer your question, you have a choice of which to file, but if you do not file a suit within the prescribed period of time, or if you do not file a IBC proceeding within the limitation period, then your time will, then you can't later file that. But you can file them both simultaneously.
You can file both simultaneously.
Yes. Yes.
Okay. No,
However,
because
after the moratorium period is issued under
if it reaches that stage, yeah.
correct, then you of course can't file any suits
Okay.
again.
See, of course, your answer is like what it ideally is for restructuring or whatever. Practically, it is used more as a
Yes, but
recovery tool, right?
legally speaking, it's not meant for recovery. Of course, most of them
Correct,
are
correct.
settled, but
Yeah.
in the eyes of the law, it's not meant for recovery.
Yeah, correct. When filing a summary suit, instead of waiting for the defendant to ask for leave to defend, the court itself has the discretion to sort of reject the plaint, right? Based on what is there in the plaint. If it doesn't if the court feels it doesn't satisfy the requirements of a summary suit.
Absolutely. I
They
mean,
don't have, yeah.
the court will examine whether you made the necessary averments, etc. But once you have made the necessary averments and it is based on a money claim, then the court is bound to decree it as if the allegations made in the plaint are admitted by the defendant.
No, and I have a related question to this. The reason I asked you, because I myself have been a victim of this,
Right.
is that many advocates manage to get a summary suit filed even though it doesn't satisfy, it doesn't have the necessary ingredients. Somehow they manage it in the court. I don't know how they do it. And that leads to a lot of problems for the defendant. So in those cases, what
Anyone
would you
can
suggest?
file anything, but then the court will also have to consider whether it falls within the provisions of Order 37. So just mere filing
Yeah.
doesn't help the plaintiff.
No, they managed to get someone sent also, in many cases. I mean, I'm speaking from experience.
Mhm.
Then we are left to, and sometimes they manage to show that deemed summons have been sent.
Summons
And
can always, see, that's what I'm saying. The filing can always be done. Then, of course, there's a question of objections of the department, etc. Once that is done, the defendant will have to enter appearance within 10 days. Thereafter, if he enters appearance, the plaintiff will issue the summons for judgment, which the defendant has to reply to. And then the court will consider whether it's, and ultimately, if the court feels that the suit is filed erroneously or it's filed vexatiously or frivolously, they can always award costs to the defendant for having had to take the trouble to come to court.
no, what I was probably trying to tell you is a worrying trend of, people managing to somehow file a
I don't know.
summary
I have
suit
not
that they
experienced
really
it myself. I practice mainly in the High Court, so I haven't really experienced that.
Okay. My question is that you spoke about the set of judgment. Can you share the details of the judgment?
Yeah, sure. I mean, there are many judgments on this topic. So one is this judgment of Sunil Enterprises versus SBI Commercial and International Bank. Then there's the judgment of Uma Shankar Kamal Narayan versus MD Overseas. It's a 2007 for SCC 133. Then there's Defiance Knitting Industries versus Jai Arts, which is 2006-8 SCC 25. So all the Supreme Court judgments have reiterated these 5 points on when conditional leave is to be granted and when it is to be refused.
Yes, I have one more question. What is the difference between a summons for judgment and a writ of summons?
So
A lot of times there's too much confusion regarding these.
summons for judgment is specifically provided for in Order 37, Rule 3, which says that a summons for judgment will be issued when the defendant enters appearance and he is given 10 days to apply to the court and disclose the facts which would enable him to the court to grant the leave to defend. So summons for judgment is only under Order 37. A writ of summons is, of course, issued to all defendants to come and appear before the court. So that is under the general procedure of suits, whereas this is specific to summary suits. If you see the provisions of Order 37, Rule 3, it provides that if the defendant enters an appearance, the plaintiff shall thereafter serve on the defendant a summons for judgment in form 4A in Appendix B or such other form as may be prescribed from time to time, returnable not less than 10 days from the date of service, supported by an affidavit verifying the cause of action and the amount claimed and stating in his belief there is no defense to the suit. Then thereafter, after the summons for judgment is issued, the defendant has to file his affidavit disclosing the facts which would entitle him to be granted leave to defend.
Whether a summary suit can be filed on a company which is already undergoing insolvency case with NCLT?
It can be filed unless the moratorium has been issued. Once the petition before the NCLT has been admitted, then there's an automatic moratorium which is issued, and therefore no suits or proceedings can be instituted or can be proceeded with rather if the moratorium period is there. So, of course, you can always file it prior to the admission of the company petition before the NCLT.
Okay, when it is pending, I can't file, right?
You can't file or proceed with it.
Thank you so much, sir.
Thank you for having me once again. Thank you very much.